Hello, guys. It seems that the US market is more interesting to the general public than MiCA. Um, we'll see whether is it because of speaker or the regulatory framework. So, yeah. um, as Anna said, I'm Ilija Rilaković. I do logistics, picking up, collecting people from the airport, sending merch, and when not doing that, I'm a lawyer and I do corporate law, tax law, and some crypto assets. Besides, I'm the one of the co-organizers of ETH Belgrade, so that's why I'm wearing this red shirt. And I have to reconsider this format of being both organizer and speaker because it's hell. Um, whoever saw this movie, Scarface, so uh, don't get high on your own supply um, because it's just does not add up. So briefly about MiCA regulation. Uh, as yes, all good. Thank you. As this is predominantly builders conference, I wanted to shed some light to people who develop protocols, mainly in DeFi. So, as you know, we have MiCA that is into force since last year, almost a year ago. Certain parts concerning e-money tokens and asset reference tokens just began to apply. But what is also expected is that, so as with L1s, L2s, L3s in blockchain, we have different levels of regulation in this field as well. So European authorities are expected to provide technical standards, many bylaws that develop framework in more details because MiCA is just a general framework that sets principles, and technical details should be done by these level 2 and level 3 measures. This is brief outlook of application of MiCA. So first part, Title 3 and Title 4, asset reference tokens and e-money tokens started to apply. The rest of it should be in application by the end of this year. So pursuant to the definition of MiCA, operation of trading platform is basically management one or more systems that facilitate trading of different cryptocurrencies, tokens, and so on and so forth. I'm not going to read the entire definition. This is just for the reference because of the later part. Yes, one more picture of how the application gonna look like. So this is also definition of what is custody and administration of crypto assets according to MiCA. Why the access is underlined? It's because it is important for the front end of decentralized protocols. We'll see why. So basically, custody provides access to crypto assets of holders. And we're coming to the main point. So when we talk about decentralized protocols, it's basically a piece of software that runs on a blockchain, and once it's deployed, you somehow have to interact with it. How do you interact with the blockchain protocol? It's usually through another piece of code, let's say website or maybe a mobile application that allows you to interact with it and use all the features that it offers. And then there is a question whether such access point can be characterized as a operator of trading platform under MiCA. Maybe it's obvious, maybe it's not. I would say it's not clear enough, and it's open to discussion. That's what I wanted to do later, to open the discussion on this, because we have some devs in the audience and the lawyers to give us their opinion, because why this is of importance for the DeFi industry is because there are serious of liabilities and obligations of operators of trading platforms. So this is just one excerpt, and what is commonly seen in terms and conditions of different service providers is that they try to limit their liability. So disclaimers which can be seen under MiCA are not gonna prevent you from being sued. So terms and conditions of those websites and mobile applications should be adjusted, and this is kind of call to action to discuss with your lawyers, advisors, your terms and conditions and the way you operate your front end, especially if you work with decentralized protocols, because your website or application is, second please, is the access point to that protocol. And what are the consequences apart from civil liability, so being sued and asked for money or damages? You can be prosecuted in your national jurisdiction under criminal law. So that's the nuclear scenario, and you can be prosecuted, but under what grounds? So you can claim that you are not operator of a trading platform, but do you want to be part of the ordeal of criminal proceedings? What might be a defense strategy, hope that it's not going to be the case, is that you can plead that law was not sufficiently clear and that you are not part of that you are not operator of a trading platform. So I would like to hear, yeah, you had question about. Okay, so any contractual exclusion or limitation of civil liability shall be deprived of legal effect. So basically, if I write, if it's written in a contract that I will not be liable for anything whatsoever, irrespective, well, as an operator, yeah, and in general, I would not be liable for anything whatsoever. It's all up to you as a client or customer. That will not have a legal effect. So it's limitation of contractual freedom of contracting. Is it good enough? More clear? So there are principles of criminal law that should be observed at any criminal case. One is that there is no sanction without prescribed crime. So it's difficult to apply the rule to prosecute somebody if the rule is not clear enough. So there is a risk that certain front-end websites or might be characterized as operators, but this is up to the up to discussion whether that would be the case. So I can open the floor for discussion now. Yeah, Viara. Um, mm,
pretty loud as well, but not that much related to MiCA in particular, because there are a lot of uncertainty there. But I'm part of an advocacy organization, and we're in Brussels quite a lot. So during a conversation I had with a representative from the European Commission last year related to the Product Liability Directive. For those of you that don't know, it's one of the oldest directives in the European Union. So now they're kind of redefining the concept of a product to also fit software product, so that there would be also liability for programmers. So the way that it was written basically brought up this question: okay, who is gonna be responsible? Like, who is gonna be liable? And the person that is one of the people responsible for writing the product liability directives new version basically said, well, it's gonna be the front end operators, because it's obviously that it's gonna be there, because we are looking for an like person entity that is bringing the faulty product, in this case, to the market. So obviously, like in their way of thinking, it's obviously the front end. So based on that logic, I wouldn't be surprised that with the next version of MiCA, like with whatever is gonna happen now with DeFi, this might be followed as a concept. Like, even though we currently have Recital 22 of MiCA, where fully decentralized is out of the scope. A, we don't know what fully decentralized is, and B, that's only until the revision that will come in the next few months, a year tops. So yeah, if that helps, I hope that helps the discussion of basically, it's always the regulator and then the judicial system, and the overall system is looking for someone, and that's usually the one that is the most obvious person, like bringing the front end.
And yeah, the fact is that front end provides access to the protocol, and if you are gatekeeper in a way, although you don't have custody over that, effectively you can prevent somebody from accessing their funds if your software is broken. I mean, front-end software. Pavle, what do you think?
Okay, so what would help maybe frame this discussion a little bit is liability in certain cases. Because for me, at least, so the first thing which was quite surprising to me is this idea that you have product liability as a developer, because I understand liability if you are how can you divest liability from, or like, how can you have liability that's direct without having some kind of chamber or licensure or something, which does not exist for software engineers or developers at all. So you can be like personally like liable. What if it's an open source contribution built by like thousands of people that are not in the same jurisdiction? Do you just pick someone and throw them under the bus? How's that even like? How is that? Okay, I guess it meets some legal goals, but it's not very productive. So I guess it's still a bit of a mess. But if we're talking liability here, like my main question is like, of course, if you are operating a front end and there is no access to a protocol without a front end, even if you run it on your own computer somehow, uh, the question is like, what is it that you're doing that you are liable for? Are you liable because you're, for example, not censoring people? Are you liable because people are trading and gambling and losing money? Like what is the problem here? Are we like setting the standard for general liability, or is there some specific like categories that we are trying to determine that front-end operators should guard against? And I guess the most important one is like, does the front-end need to identify its users, and how deep does this identification have to go?
I'm not sure that we don't talk about identifying the users immediately. It's how that service provider, that front-end developer, is responsible, and where the limits of his liability and responsibility for the code it provided to DEX. Yes, Martin.
So when it comes to front ends, so with Uniswap, it's clear that like you have the Uniswap front end, but you can also interact with Uniswap through Etherscan, and you can also send transactions via an RPC via curl. So is it clear what classifies as a front end? Where is the line drawn?
For the purpose of this presentation, what I had in mind are websites and mobile apps, not Etherscan. So I try to narrow a little bit down the scope. You had a question?
Yeah. Actually, I was curious about like the practical implementation, like what is considered to be the loss of funds. Because, for instance, let's envision some practical examples. Like I'm trading on Uniswap, for instance, and I buy a token, a custom token, which I add manually there. It's not in the whitelist, and this token is pumped and dumped, and all the money are gone. Like I spent like $1,000 to buy 1 billion of Pepe meme coins or whatever, and now they cost nothing. Is this considered to be a loss of funds?
No, I think it's just your poor investment decision, not the loss of funds or liability of either DEX or front end provider.
So it's only about like exploiting the contract, or if the Uniswap contract is exploited, for instance, like all the pool money are gone, and I'm the investor in this case.
No, as I explained, once the smart contract is deployed on blockchain, you basically can't do anything. But you provide a gate through which you access that smart contract. So that's the question. So are you, as access point, so front-end developer for that DEX, liable for customers not being able to access the blockchain, or potentially losing the funds due to some exploit of your
Others, not mine.
Yeah,
some other
like
guy. Yeah.
in general. I don't have clear answer. That's the reason why it was this was interesting to me to discuss and to present, because although it might be clear that front-end provider is not offering custody services, in effect, it's access point through which you can either have access to your funds or no.
And the last bit of a question, like, are there any practical cases someone got prosecuted or like sued under these regulations?
I don't know, to be honest. And this is new piece of legislation, so it might happen in the following years. We'll see.
Yeah, because
Mladen?
Down there? Okay.
So thank you for the great presentation. I have a question, because we are now living in the decentralized world. This means that the front end can also be decentralized, for example, through IPFS. Now, is the provider the developer, or because who is then liable for?
I'm not sure. So that's a good question. Since this is new, I'm not sure that I can answer it. But it's a good one.
Yeah, and in essence, then as a backend developer, I can write anything, and I'm not liable, and put it on the blockchain. Or is there some piece of legislation that is working with the smart contract developers?
I don't think that you can escape the liability just because of you are in backend.
Yeah, probably just to add to that, the recent case of Tornado Cash basically says that you can still be liable. Even they're using arguments such as, okay, you are actually one of the top 3 contributors to GitHub, so and you have been throughout this time been visible, telling about the project. You're obviously contributing to the project. You haven't stopped contributing, so they're kind of this information in connection with similar information would, in some cases, be enough for claims to be made.
There are few cases that I know. Ukidao case in the US, and of course Tornado Cash. They were just providing a smart contract, so they did not launder the money, but
I have a non-legal question.
yeah.
Which projects are doing the best job having decentralized front ends built in their ecosystem? Like, for example, I've seen it with Liquidity. I'm just curious if there are others that have done a good job of completely independent teams building the front end to interact with the smart contracts. Do you know of any?
No, to be honest.
Does anyone in the room know any?
That's the mic.
So, unfortunately, there's no such thing as from what we're seeing. Like, we're not talking about any kind of exotic way in which you're interacting directly with on-chain services and sort of assembling everything in your own house. There's no such thing as a decentralized access point to a Web3 application because it's going over the internet, and the internet has an IP address that you're targeting a server. Whoever holds that server, in this understanding, will be liable. Even if you're following this cockamamie logic, which is like, oh, you were a contributor on GitHub, like the law will find somebody whose head it will chop off. It doesn't matter if it makes sense. They'll just do it because that's the way the law operates. So liability has to be found for this legislation. Now, as far as I understand, there is it's a little bit more clear to me. Sorry, when I asked the first question, I was totally confused. Now I'm a little less confused, but I'm still confused. The thing is, essentially, if the fact that you're talking to a piece of decentralized technology that's like immutable and so on and so forth, doesn't mean anything because the app that you are interacting with can tell you anything. Your wallet can lie to you, your app can lie to you, everything can lie to you. And I guess this is where liability sits. Now, this is a big problem because there have been, even in Web3 and outside of Web3, there have been like attacks, supply chain attacks, where the app will show you bad data and you will make a decision based on bad data and you will incur a loss. So this is actually a good thing that the EU is targeting because in the end, you should be liable for operating something like this. It is something that can be looked at and can be mitigated potentially through security practices and so on and so forth.
This is something to begin with. As I said, it's a new piece of legislation, and it remains to be seen how the technical standards will be finally developed and rolled out, and how the front-end operators, service providers will be perceived. And this is what lawyers do, discuss different scenarios.
And I would just like to ask you specifically a question, like, what do you see as the overarching goal of this legislation? Is it basically just bringing crypto in line for it to be tracked for tax purposes? Is it that, or is it something else? I always found MiCA difficult to pin down as a layman.
It's tough one because so okay, MiCA should be good because it finally puts together all critical parts of crypto industry under one chapeau, let's say, and aims to unify the European crypto market, because, and that's why this is regulation and it applies directly, unlike directive when it sets minimum standards and national jurisdictions should develop it further. So set minimum standard in order to unify the market. With regulation, it applies directly. And I guess that's that's why European legislator opted for this format of law, so direct application. Łukaszyn. Last question, I guess, to be on time. Yeah.
All right. So with Serbia kind of wanting to join the European Union, do you see Serbia following MiCA with like how it did with the GDPR, and how compatible is it with current Serbian regulations?
So Serbia is on accession path to the EU, and our law on digital assets generally follows the logic of MiCA, although different terms, different conditions. But in some parts, it's more appealing to the projects who which want to not to say escape, but to mitigate the regulatory burden that MiCA will introduce. For that reason, we already in my legal practice, few leads on crypto asset service providers who wanted to open a branch in Serbia in order to be able to operate in Europe without entirely complying with MiCA. That means that, which does not mean actually that you can avoid it entirely. There are some reverse solicitation clauses which prevent you incorporating, for example, in Serbia or Macedonia or Albania, and targeting actively European market. That's not allowed. That's targeted by this regulation. So I think that in near future we will have to adjust our regulatory framework and our law with MiCA, but it's long way to that point. So like with GDPR, I think we will at some point have to adjust our law with this regulation.
Last question, I promise. Just a yes or no. Are they gonna KYC everyone? Yes or no?
I guess no.
Yes.